Number 14. I am withdrawing because I am challenging the acquittal award with liberty to file appropriate form.
Appellate order acquittal recorded by appellate court.
Yes, Maharaj.
Mr. Bhavesh J. Patel, learned advocate for the petitioner, on instruction, 6, permission to withdraw this petition with a view to file appropriate appeal before appropriate forum in accordance with law. Permission as prayed for is granted. This petition stands disposed of as withdrawn.
Okay.
Right.
The serial number 10. I need to file a paper book containing the evidence. This may request for
What is the petition?
the order? Yes, the order is passed in my discharge application. So I
paper book नहीं
have evidence. I am relying on the evidence to point out that there is, so far as the applicants are concerned, there is nothing against them. So far as the DD and all is concerned.
From the order, it can be read. It is not required at all.
Let me refer. That's next week only on Monday. That's next 7th. I'm sorry, 14th.
Exam on request next week. What is the stage of trial?
But it is at the framing of the trial and it is on 15th, therefore 14th. Before the trial court is on 15th, so I am requesting for 14th.
Silver 12. Silver 12.
Yes.
My lords, I have one matter coming before the Division Major Honorable Justice Desai, which will clash. I'll finish that matter and then forward, if my lords will permit that.
In the first call, I may give it back if you can come back.
I'll take a chance, sir.
All right. You take a chance or else it will be attended. Don't worry.
If I am not here, then maybe tomorrow.
All right.
I'll take a chance, but
Sure.
wait.
Number 22.
Number 28.
Yes.
The other side is 5-6. I have some urgency because I am facing execution applications. Straightway, the arrest warrants are issued against my client, and he is not able to leave. Reside even in his own house. Therefore, request is
Why you are not paying the arrears?
So I already cleared all the areas. All the areas are cleared.
Let it be called out then. So next.
What's number 21? I'm mentioning on behalf of Mr. Sandeep. May I request on next week?
Exam on request next week.
Number 32, 44.
Lordship, serial number 33. I'm mentioning on behalf of Mr. N.M. Kapadia. We have received to withdraw the petition.
No. You are Mr.
I'm R.N. Kapadia.
Mr. R.N. Kapadia, learned advocate for Mr. N.M. Kapadia, learned advocate for the applicant, places on record a communication and by applicant addressed to the learned advocate representing her, stating therein, instructing therein to withdraw the. What is other application, sir?
Lordship, that is one criminal miscellaneous application in CRA.
All
That
right.
was both applications.
Withdraw please. Aforesaid, withdraw the application praying for condonation of delay. In view thereof, the said communication is taken on record. In view thereof, this application praying for condonation of delay caused in referring the aforesaid division application is hereby permitted to be withdrawn and stands disposed of. In view of the disposal of withdrawal of the delay condonation application, no order is required to be passed in the criminal revision application number 49 of 2020 and it stands disposed of.
Obliged.
Lordship.
Lordship, serial number 39. I'm mentioning on behalf of Mr. Rawal. Lordship, there is a leave note on other side. Lordship, we have filed one CRMA 1 of 22 for directions on requesting it. It may be listed with this.
This CRA is awaiting admission yet, or now it is admitted?
That I'm not aware of.
Alright. Next week, leave note by petitioner advocate next week. Separate document.
Okay.
Which concerns the information person by
Is there any stay granted?
no, but here, no, only not. No. Here, challenge actually 5 order matter. Here the defendants.
Since specially assigned, have you taken consent of other side?
Yes, ma'am, with consent.
With consent adjourn after 2 weeks.
Ma'am, public.
Number 3, man.
Yes.
Yesterday I was sick, therefore I filed the sick note. Unfortunately, this matter will be kept for the moment. Today I am also not well, but since 10 days I am so sick now. Therefore, at least 15 days may be given. I am requesting to.
You are challenging order of discharge,
Order of
rejecting
the lower
discharge
court.
application.
Discharge application, one complaint was given to the police, and the FIR was registered. Thereafter, the contempt petition was filed in the lower court. That is the matter.
The request adjourn after 2 weeks.
24th. I am blessed.
What about this serial number 2? Mr. Alvi? What about serial number 2? Waris ALV? Who is?
No, he is not.
He is not related to you?
No, I am not. Sure. I am blessed.
Right. Yes. Adjourn on request.
Circulation of matter for user admitted the matters are the second color. Application for circulation of the user application. The reason for circulation matters the settlement between the party matters. If matter, please permit me to circulate.
It is settlement is on record when party
No
is
matter, no matter.
all right. Party is to remain. It is under negotiable instrument.
No matter, it is understood 324 25 of
324, 325. It is compoundable. Just check Mr. Sharma. You just check 324, 325 whether it is compoundable and
Yes.
permitting the circulation.
I will check that it is compoundable.
If it is compoundable, then all right. Otherwise, let it be first circulated thereafter.
Tomorrow, any date,
Thereafter.
Madam, I'm requesting for circulation of a matter. Yes, tomorrow if it is convenient to my lords. It
What is
a
the
revision
matter about?
application. It is against the conviction against the cruelty of animals prevention act.
Conviction recorded by magistrate or by sessions court?
By sessions court, my lords.
Sessions court.
The conviction
Trial held by the sessions court.
JMFC. Then appeal was.
There you were convicted.
Yes, my lords.
Sessions court dismissed your appeal.
Yes, my lords.
Have you surrendered to the custody?
Yes. We have already 1 month has already passed in imprisonment. The conviction, the sentence was of 3 months only, my lords.
No. After dismissal of your appeal, are you in custody or
Yes,
not?
yes, my lords.
Since when?
Since past 1 month.
What were you doing? Had you not file any appeal, a revision against that order here for 1 month?
No, my lords.
Permit circulation day after tomorrow.
Obliged, my lords.
sorry, I missed my number 38.
Yes.
I'm requesting for 1 week's time or any, I have informed my, the colleague of Mr. Jappi. I'm just requesting for 1 week's time or any,
Is there any consent?
sir, I informed her. She said that,
All right.
please,
2016 maintenance matter.
please,
here?
my lord, please.
What happened to that matter?
Sir, it was dismissed on the ground of territorial jurisdiction because she could not prove that whether she is the permanent resident or she is residing there in Gandhinagar, and therefore it was rejected on that. Sir, I am ready with the matter. I'm just,
It's a very short issue.
I am ready with the matter today also, but today if at all, my lord.
Today only it will be called down. Perhaps thereafter it may not be.
Please, my lord.
Be here then.
Very well.
All right. Wait.
Please.
Yes. Yes. Recently you were out on follow there. This application. Mr. Mirkel already limited advocate for the applicant, on instructions, 6 permission to withdraw this application. This application stands disposed of as withdrawn. Oh, you absconded for 575 days. Your conduct is also not good. So, Mr. Hardik Kothari will advocate for this applicant, on instruction, 6 permission to withdraw this application. This application stands disposed of as withdrawn. Who is appearing here?
Please.
Have you seen that he is drawing pension? He has been released twice for furnishing that certificate.
Yes.
If he is drawing pension, why he can be released to support financially to the family? Because twice he has been granted temporary bail for filling up that form of existence.
Yes.
That he is still living. Oh, he is not released
Yes, that
for 2 years up till now. He is not entitled for furlough, perhaps. If he is entitled for furlough, why he is not being granted? You just obtain 2 instructions. Get from instruction from the either the IO or from the papers of appeal. Find out whether he was drawing pension when he because offense is of 2014. Perhaps after his retirement, he might have committed this offense.
I'll get it right away. Because one thing that since long he has not been released, I'll verify the
Verify.
credentials.
And is he entitled for furlough or
Yes.
not? And if yes, why he has not asked for furlough? And then next week, mother.
Yes.
The applicant was already released on temporary bail for a period of 10 days for the very same purpose. You cannot ask for the temporary bail for the very same reason on the ground that it is incomplete. And this application is rejected. NDPS accused 6 years as coming out from the jail remarks. He is in jail since he has already completed 6 years and approximately 4 months by now in prison. The registry is directed to notify his appeal for the purpose of hearing. Then in view the hearing, even in view thereof, this application stands disposed of.
Because you have delay of 116 days in preferring your revision application. It's the main 116 days delay.
16 days. What is the revision for?
The revision is for quashing of the maintenance which is granted ex parte by the honorable court, honorable learned court knowledge.
That order is dated
Dated 25th of 11/2021. That's what had happened, that when the summons was served, I appeared through my lawyer. He filed my written statement, but thereafter my lawyer didn't appear, and the learned court proceeded ex parte and granted an amount of rupees 6,000 to my wife and 3,000 to the minor child minors. Minors may kindly have page number 35 of the main matter, minors. That's the matter proceeded ex parte. The observation is page number
The
20.
matter should be proceed ex parte because you had, after filing your reply, neither you nor your advocate remain present.
Because therefore
Or
I
may
will
not come to your house for conducting a case.
please, my lords. Therefore, my lords, when the matter proceeded ex parte, I was not aware that my lawyer was not
Who will
appearing.
be aware then? If you are served with the summons, you engage an advocate.
My lords, may kindly have page number 21. I had already engaged. My written statement was filed. My lords, may kindly have page number 21.
I have seen that. Read page 22, para 3.
Please, my lords. Thereafter,
Don't say
I was
again
not
and again
informed. my
that-
lords.
Yes. Is it not your responsibility to ascertain?
Please, my lords. It is my responsibility, but
Then-
somehow the matter proceeded ex parte, my lords.
It has to proceed ex parte. You can't keep court waiting,
Please, my lords.
and you cannot then complain that it went ex parte.
Please, my lords.
You are responsible for it.
Please, my lords.
What is the arrears as of now?
My lords, I have not paid anything on that.
Deposit. What is the arrears and deposit part of it?
I'll take a sense, my lords.
Take the sense. Rule returnable only on condition that the applicant deposits rupees 5,000 as a cost to be paid to the respondent wife and minor son. But registry to issue the notice of rule only after the aforesaid deposit
May I
is
request
made.
this, this is a legal aid matter. If some cost may,
No,
that's,
legal aid, that doesn't mean that you have to be.
no, my lords, what I just only, if I may indicate, my lords, I had already applied for a certified copy in the month of December. When I came to know that an order was passed ex parte against me. Thereafter, I tried to save the entire amount and I came to know that legal service authority is providing legal aid to the downtrodden people. And immediately I would approach, my lord. There is no.
If you want rule or deposit entire amount of maintenance.
Some reasonable amount.
No.
my lord.
No reasonable amount. This will be the cost only for issuing notice in this delay application.
Please, my lord. Grateful.
Further order will be passed later on.
Grateful.
The offense under 302.
Hmm.
The husband also tried to commit suicide. And his dying declaration was recorded. Now that dying declaration is exhibited in the trial.
It has to be.
No, he survived thereafter
Recorded by magistrate.
by magistrate, but then he survived. So it is not a declaration of witness. He is an accused. So
Accused cannot give any statement.
accused, but it can
This
be
is not
exhibited.
before police, mister.
No, but then
Therefore,
I understand. But then
Ah.
it can be exhibited. That
Who
is
says so?
blood. The confess. Otherwise, blood. The when the person survives, the contours of 32 will be over.
Yes.
Now, once it is over, even in case of witness, it can be used to corroborate or contradict.
It will become a statement under 164.
No, Lord, it
Why?
is executive magistrate, then not 164.
Then
Lord, if your lordship sees, it is not a confessional statement as well. When it was
yes. Then what was his statement?
that this incident happened, I also committed suicide. And then that was the statement given at the time of it.
Basically, this statement is before an independent person, not a police.
Correct.
So,
But in presence of police and all, it's factual. That is factual. Yes.
That part is saved by the court. That admissibility and evidentiary value of the statement would be looked into at the later stage.
But issue is not this. The only distinction is that if it was statement of a witness, suppose injured witness gives a dying declaration, then he survives. But that dying declaration can be exhibited, can be used for corroborate and contradict the witness. But same analogy will not apply for the accused. This is what my
Give me any reason.
yes. Not the reason first would be that this statement will be hit by 24.
But it is only be recorded before the police. Then only it would be hit.
No.
Love it.
Okay.
Evidence setup. Major record. Major.
N20 both. So not even an extrajudicial confession would be my case.
If it is obtained by inducement, threat, or promise, mister, then only it is not admissible. Here it is voluntary. You can't invoke this 24.
If your lordship just sees the evidence, I'll just in a minute. Then
it is altogether a different thing, mister.
Page 12.
Which is saved by the learned judge. Evidentiary value of that statement or the deposition of executive magistrate.
So whether it is admissible or not will be not only problem is that this would be read in my respectful
It has
submission.
to be read.
Now once it is read,
prohibition, then it can't be read. or it can be exhibited. It is not
On
it
prejudice,
is surely not a statement before the police.
it is surely not. So 25 will not apply. I understand.
And if you want to argue section 24, then you have to show that it was by way of either inducement, threat, or any promise.
So one, this,
That is also eliminated.
look, please see this para 14 of this judgment. Just 99. 99, 5 SEC.
Gangula Asoka?
No, Ram Prasad.
Ram Prasad. His statement is not admissible under 32. Under 32, it is not to be admitted, Mr.
So this, in fact,
Then
this
it-
was
then it would become, if it is like a confession, it would be exhibited and read into the evidence also.
para 14 and 10. I'll
Confession
immediately
statement-
take. Look,
confession statement
ultimately,
of approval
accused
given to
statement.
magistrate.
I'll just can be considered under 27, save for discovery of some fact. And 164.
It is before a police.
So,
Any statement before a police cannot be exhibited.
that's right.
I am
So-
clear on that point.
I am obliged.
This is
So,
the
so
statement
ultimately,
recorded by executive magistrate and then to voluntarily.
look, there are two. I would say there are two submissions to what is falling from the honorable court. One, that statement of the accused can find way in the investigation or trial only in two circumstances. One is under 27, another is 164. Now, this is admittedly not 27. It has to be treated under 164. Now, please see 164, therefore, and then para 14 of this judgment. Now,
Yes.
164(1).
Yes.
Any metropolitan magistrate or judicial magistrate, whether or not he has jurisdiction in the case, record any confession or statement made to him in the course of investigation. So this is before an executive magistrate who was considering during the course of investigation called for the purpose of recording statement under 30.
Mr. This is the basically not the confession statement recorded under 164. It was recorded under section 32 by the executive magistrate.
So
if person making statement survives,
correct.
if
So
it is
32
of a-
rigors
if it is rigors of 32 will not apply.
will
I'm
not
on
apply.
that.
So then
But
there will be
admissibility-
extrajudicial confession.
Yes. and
Now
before
extra
extrajudicial confession in writing recorded by independent person.
correct. So Lord, what happens is that when an extrajudicial confession is to come, that person's testimony only is to be seen. His blood in normal suppose if he was not an executive magistrate, he was an independent person, say sarpanch or a friend, and an accused says ke mare thi avi bhul thi. So it would amount to extrajudicial confession. That fact will come under 161 statement.
He is required to be examined only because his statement was recorded before the police.
During the
Here,
investigation.
executive magistrate statement is not recorded by the police. He himself has recorded the statement of that very man.
That is that. That is all.
You also just apply your mind.
I understand.
You also assist
I
the court,
understand.
Mr.
So this is how I
Only one aspect. Today, essentially, is the challenge is to exhibiting the document.
True.
Under which provision is a subsequent. It cannot. It would be at the stage of when the evidence value is to be considered.
If it is not admissible, it is not admissible. If it is admissible, even if he challenges it, it becomes admissible. That you also apply your mind from this angle. Probably this statement can go on record. You have brought sufficient material to dislodge the deposition of
That's
even
right.
to executive
I
magistrate.
understand.
So
એટલે એવી ચિંતા નથી પણ તોય આ જો ના prejudice ના બીજું
anyway, but you also
I understand.
you also assist the court, Mr. Prima facie, this is the reaction.
I agree.
But you also
let me
apply your
work up
mind.
the rod to pieces.
When should I keep it? Monday, next Monday.
Next Monday will be fine. 14.
Next Monday.
Lordship.
14.
Obliged.
And what is the stage at present?
The trial is going on. So
How many other witnesses
there
are
are
there?
3, 4. So
All right.
not pressing. So 14th.
14.
Lordship. Obliged.
You also have you given him the copy of this?
I have. This 99 I'll just immediately.
Yes, Mr. Darji.
Lordship, petitioner convicted under section 130 of the 138 of the Negotiable Instrument Act and ordered to undergo 1 year simple imprisonment and order to pay 1.5 times of the check amount. However, I have paid 50,000 during the trial, so that amount has been given compensation, and subsequently during the appeal, I have also paid as 20% of the check amount. And
What was that amount? 20% means?
I have during the appeal, I have paid 50,742 rupees.
50,000.
55,000, sorry, Lordship. 55,742. So altogether, I have paid
So more than 1 lakh rupees you have deposited already as against check amount of 278.
278,710. 1,05,742 I have already deposited,
All right.
Lordship.
Are you in custody at present?
No, Lordship, I am
No.
not in custody.
Rest of the amount will be deposited within what time?
Lordship, I have
Otherwise, you shall have to surrender to the custody.
Lordship, may I request that 8 weeks, Lordship? 8 weeks, Lordship.
8 weeks is too much. It is only 278, out of which 1,05,000 is already deposited.
Lordship,
So remaining 1,20,000 around
72,000. It will be 1,72,968.
Hopefully it comes to that. For that 8 weeks, you will not.
Then Lord, I will leave up to Lordship, whichever time Lordship.
And what is the other? Any fine is imposed or only compensation?
Only compensation, Lordship. That is that
એકની દોઢી રકમ એટલે 4,18,000, 50,000 ચૂકવ્યા એટલે 368. You deposit the remaining amount within 4 weeks.
1,72,969. Lordship.
Remaining check amount.
Lordship.
Deducting what you have deposited.
Lordship.
Thereafter, after hearing him, it can be considered whether the compensation as awarded can be stayed or not, or it can be granted to him or not.
Lordship.
And see that it is settled.
Lordship, I actually that want to settle, but there is some financial difficulty.
Mr. Financial, if there is no financial difficulty, check would not have been written back. But once you have, or rather you have been convicted, that means that you had issued the check, that is proved.
Lordship.
That check must have been issued against a legally enforceable date.
Lordship.
So amount which you have taken, you are supposed to return it back.
Lordship.
So even if whatever the financial difficulty, you are supposed to pay him.
Lordship.
Right? Or Mr. Chetan Darji, learned advocate for the petitioner that's accused. According to his submission, out of check amount of rupees 2,78,710, during the course of trial, 50,000 was already paid to the complainant, and at the time and at the appellate stage, rupees 55,742 was already deposited as a condition of an appeal.
Lordship.
He has further submitted that the petitioner accused is ready and willing to deposit remaining check amount within a period of 4 weeks from today before the registry of this court. Hence, notice returnable on. Registry is hereby directed to accept the amount as aforesaid if deposited on or before the returnable date. Till then, order directing payment of compensation to the complainant is hereby stayed. Deposit that amount, yes.
Order of the sentence may be, order of sentence also may be stayed.
Another submission है मतलब till then furthermore, but till then compensation is still. Furthermore, if any warrant against the petitioner as accused is issued for undergoing sentence, it is hereby stayed till the next date of hearing. It is also stayed till the next date of hearing.
Obliged.
Yes.
I have received this file in the morning. I am replacing Mr. Patel. So I have some facts that it is a 58 lakh rupees check which was got dishonored. Then after the case, criminal case, they were convicted. The lady was convicted. Appeal was filed. In the appeal, there was an order passed for to deposit 20% amount. Page number 51, that amount was not deposited, and therefore the appeal got dismissed lordships on non-payment of that amount. That is what the case before my lord.
What is wrong in it?
I have to just pay. I have to take instruction from my client that you have to pay this 20% amount, and you have to go back and conduct the appeal. That is what my request. But since in the morning I have received these papers from the another advocate, my lords may kindly keep it on Monday or Tuesday. I will get the sense that you have to anyhow you have to surrender to that order. You have to deposit it, and it may be given remanded to the court because there is no order passed on the merits. Page number 51, my lords may kindly see ek piche hukam. So it was because
અરજી આપતા ચેકની રકમના 20% રકમ કોર્ટમાં જમા કરાવવાની શરતે તેમજ રૂપિયા 15,000 જામીન રજૂ કરવાની શરતે સ્ટે કરી આપ્યો તો.
Yes, yes.
બરોબર.
I have read that page number 51.
You were granted time.
Many, yes.
Twice.
Yes, yes.
Time was extended.
Yes.
Twice.
True. Yes.
Despite that you have not deposited.
That is why it was. Otherwise, there is no merits. But even I am just because in the morning I have received. Otherwise, I could have ready with this. I'm going to deposit it.
This order of dismissal is dated 3/10/2000.
3/10/2000.
And you are not in even custody.
Yes.
If you go in custody for a day, it will be immediately deposited.
So, so I'll take.
So long as the accused is outside the jail, he will have so many excuses. Once he go inside the jail for a day, then immediately that amount would be deposited.
But I'll just get the sense and I will make them an impression.
The request of Mr. You are Mr.
Jabuawala.
Mr. Jabuawala, learned advocate, for Mr. Manan V. Patel, learned advocate for the petitioner, SO2 next week.
Please. Please, Lord. Much obliged.
Present application arises out of order of Sessions Court, Gandhinagar, appellate court judgment dated 21st of October 2022. This lordship, the sentence is the judgment of the trial court was upheld as it is by the honorable court, discarding the fact on record that I have deposited 25% of the said amount with the court and remain other 20% amount before the court to the advocate of the other side, and the complainant's advocate, and the receipts are also on record of the court. And this fact has nowhere been narrated by the honorable appellate court in the entire piece of the judgment.
All right. Have you argued that before the court that you have already deposited or paid this much amount?
That everything is exhibited on the appellate before the appellate court.
Where is that? Take me to that discussion or as your argument before the appellate court.
Lordship, may please see the last 4 pages of the paper book.
Page number?
Page number 140. I may please be allowed to read from page 143, which is the typed copy of my oral arguments before the court, wherein the entire facts of this present case. Also, my lords, I submit that these are the 2 checks which the matter has are by way of security.
So this page 143 is what?
It is a typed copy of my arguments which I had submitted, and it is as per the exhibit 21. It is an exhibited document before the appellate court.
You were not represented by any advocate?
I was represented.
Then,
But lordship, my representative.
Why he had not argued that point?
Lordship, I had argued, but it is nowhere appreciated by the court in the judgment. And
this Jai Bharat Sathe janavannu as if you are just informing the court, and that too signed by the litigant, not by even the advocate. And advocate is also not arguing. How court is concerned with that? Is the court supposed to pass any order on that application?
It is recorded, my lords.
So it is recorded. Well
But
and good.
lordship,
Recorded. That doesn't mean that court has to consider it if you don't argue. એટલે કોર્ટમાં કાગળો નાખી ગયા એટલે કોર્ટે જે કરવું તે બધું વાંચીને કરવાનું એમ તમારે કશું આર્ગ્યુ
but
નહીં કરવાનું.
lordship, at least before passing the judgment, it is a
એટલે એક એક્ઝિબિટ પડેલા કોર્ટે વાંચવાના. તમે આર્ગ્યુ કરો મેટર તોય
lordship.
તમારી ભૂલ નહીં કહેવાની કે વકીલની ભૂલ થઈ કે આ પૈસા ભરેલા હતા એ જાણ ના કરી એ નહીં કહેવાનું.
Lordship, it is,
Court is supposed to read that exhibit 21.
yes, lordship.
Under which provision it is there? Show me. This is no written arguments at all.
Lordship, lordship, we have also argued before the trial court as well. And lordship may
Trial court has also not considered your argument.
no.
Show me your argument from the judgment of trial court.
Lordship, may please see page 107.
107. Yes.
लिखित दलीलों.
Orally, you argued the case or not before the magistrate?
Yes,
You argued orally.
Yes, we have.
Then why court has to look into your written arguments if you orally argued the case before the court?
It is Lordship, in the trial court, it is my duty to also.
No.
I have the. I can. It is. I can also file my written arguments as well.
Yes.
Also, my lord, the complainant has admitted that his handwriting in the paying slip when he deposited the check before his bank, and also the same handwriting, the court has also powers to compare it with the check. I can right now also show the same to my to Lordship. The check and the handwriting of the paying slips are same. Page number 82. My lords may kindly see.
So it should be under section 314, written arguments are only the concise statement which you argued. It should not contain any other thing than you argued.
Pardon, sir.
Under written arguments under section 314, that written argument should contain concise statement what you argued before the court orally.
Yes.
Not anything else in it. Therefore, you show me that you argued that you have deposited this much amount before the court. You did not argue that.
No,
you just
sir.
recorded it in your written arguments.
Yes.
That written arguments are not supposed to contain some more facts than you argued.
Lordship, but where the 50% of monetary amount is already submitted before the court, it is the.
You have not deposited it before the court. You have paid it to the advocate of the complainant, not even to the complainant.
No, sir. 25% before the court depository, and 25 before the court.
So court can take cognizance of only 25%, unless complainant admits that he received that 25%.
It is
Show
received
me
by. Yes.
complainant. I am talking about complainant, not the advocate of complainant.
Yes.
Complainant ના વકીલે complainant ને આપ્યા કે નહીં પૈસા એ કોને કહે છે?
Right.
Complainant ને ના આપ્યા હોય તો complainant કહે છે કે મારા વકીલ ના આપ્યા એટલે આવી ગયા એવું થોડું કહે છે.
Right.
Why you gave it to the advocate of the complainant and fee બાકી હતી?
At the instruction of the complainant.
ક્યાં છે એવી instruction?
Oral instruction.
You are in a court of law. Everything is to be in writing.
Yes, sir.
No oral.
But sir, if I am handing it over before the court, then it is before the court that it is delivered to the officer of the court.
Show me that in presence of the court you have given it to the advocate of the complainant, and court must have reflected that it has been given in presence of the court. It will not be there. વકીલની ફી બાકી હોય એટલે ભળી ગયા કે ભાઈ મારે મને આપી દે હું આપી દઈશ. રોકડા આપ્યા હતા ચેક આપ્યો હતો?
Cash.
હા એટલે એની ફીમાં જમા થઈ ગયા. બંને વકીલની જમા તો એક જ ને, ફરિયાદી ના કે એક્યુઝ ના.
Then the court should.
Unless you show me a statement of a complainant that what you paid to the advocate of the complainant acknowledges that it has been received by him, then only I will take into consideration that part. Otherwise, whatever you deposited before the court will be considered.
But sir, if I am an advocate, is first an officer of the court.
Yes.
If
every advocate is an officer of court.
Yes. So if the accused is depositing handing over certain amount to an officer of a court,
show me that
then
the
the
law obliges him to give it to the officer of the court and not to deposit before the
then
court.
the court should always see that
court ને કઈ ના આપ્યા હતા તમે એને?
it is on record.
क्या से बताओ?
Before the court, that
क्या से बताओ?
receipts, handwritten receipts are exhibited by the court and recorded.
Show me that.
Annexure J. Kohli, page number 132 to 139.
These receipts were produced or referred to by you while you argue the case before the appellate court.
Yes, sir.
Well, take me to that argument in the judgment.
In the judgment, it is no. never
Argument
cited.
માં તો હોય ને તમારા જો ખરેખર તમે એને ચૂકવી દીધા હોય તમારા આર્ગ્યુમેન્ટ માં હોય કે ના હોય એના વકીલને મેં ચૂકવી આપ્યા પૈસા આ રહી પહોંચ ક્યાં એ પાછળથી ઊભી કરી.
These are certified copies, Lordship.
What is certified? It is not a certified copy.
Lordship, page number 136.
136.
That one is a certified copy for amount of 1,25,000. Then page number 130.
એ તમે કેમ સામાવાળાને આપે એના વકીલને આપવા હતા ને
So as per the
તો રેકોર્ડ બને આ એક્ઝિબિટ થયેલો ડોક્યુમેન્ટ છે કોર્ટ રૂબરૂનો અને એનું એન્ડોર્સમેન્ટ છે વકીલને આપ્યા એ કોર્ટ રૂબરૂની સર્ટિફાઈડ કોપી છે બતાવો મને આ એમાઉન્ટ એને મળ્યા બરાબર ગણી શકાય કારણ કે એને કોર્ટ રૂબરૂ સહીએ કરી છે અરે ફરિયાદીના એડવોકેટ આજ રોજ ફરિયાદી વધી હતી એમાં રૂપિયા 1,25,000 પૂરા રોકડા મળેલ છે.
Yes, sir. Sir, 3 receipts are for 1,25,000, then 50,000, and then there is one more third receipt, and that way
show
2 lakh.
me this 1,25,000 is the only receipt which is payment before the court by way of a purchase, which is one basically not a purchase, even adjournment application, and which refers that you have paid it to the opponent and advocate of the opponent acknowledges it.
Then at page number 138, it is as per exhibit 22.
એવા કેટલા તમે ટૂંકમાં ભર્યા એ મને કહો 11 લાખ માંથી
2 lakh
1,75,000.
And the third one is Then page number 138, 50,000.
એટલે 125 ને 50, 175 બીજા આ કોર્ટ રૂબરૂ આપેલા છે એટલે. And on that order of the court that adjourn, because it is adjourned and
I'm not having the receipt of 25,000, but I have handed 25,000 as well. And in short, 50% of this 11 lakh of total amount I have already
50% you
paid.
can't argue, mister, unless you show me that 50% is paid.
2,75,000 before the court depository.
Where is that receipt? એની તો પહોંચે તો આવી જશે રજિસ્ટ્રી है.
Annexure I, my lord.
Page.
Page 122. Page 122 onwards. Total I have paid in slots with the permission of the court.
130.
બધા એપેલેટ કોર્ટમાં ભર્યા કે ટ્રાયલ કોર્ટમાં ભર્યા?
બધા એપેલેટ કોર્ટમાં.
કોર્ટે ઓર્ડર કર્યો તો ભરવાનો તમને કઈ રકમ?
Yes,
તમારી જાતે ભર્યા?
No sir, for the admission of the petition.
એટલે કોર્ટે ઓર્ડર કર્યો છે ને આટલા રૂપિયા ભરો તમે 20% લેખે.
It is mandatory.
Where is that order? Yes, આ રિસિપ્ટ કોર્ટ રૂબરૂની 2,75,000 રૂપિયાની છે.
Yes lord.
એ સિવાય કોર્ટ રૂબરૂ તમે ભરેલા 1,75,000 જે મુદત અરજીમાં તમે રોકડા આપ્યા અને એકનોલેજ કર્યા ફરિયાદીના વકીલે અને એના આધારે કોર્ટે એડજન કરી મેટર. 4.5 લાખ રૂપિયા તમે ભર્યા અત્યાર સુધીમાં.
5,25,000.
એની બાકીના 75,000 ની મને રિસીપ્ટ બતાવો.
Lordship, page number 132.
ये तो घणी काढ्या मैं ये थिंग टोटल 175 થયા. 132 એ તો તમે વકીલને આપેલા પ્રાઇવેટ રિસિપ્ટ છે. એ રિસિપ્ટ કોર્ટ રૂબરૂની નથી એટલે I will not take it into consideration. This amount was paid to the advocate or the client?
Advocate sir.
Then I will not take into consideration. This is not before even the court. Yes. So there is a 4,50,000 deposited. You are ordered to undergo 2 years imprisonment.
Yes sir.
And Any fine is imposed or
No,
compensation is
no.
awarded?
Compensation or to equivalent to the amount of
Amount
the check.
of check. All right. Remaining the amount 6,50,000. In how much time you will pay or deposit before this court?
1 year, my lord.
No. Then go into custody first.
6 months.
No. Upfront payment within 4 weeks. Total 6,50,000.
My lord, at least 2.5 months.
No. Only 4 weeks. This appellate order is dated
21st October 2022. Appellate court order.
Yes, it is 12th October. Warrant is issued against you by the trial court?
Still not.
Still not issued. Deposit the 6,50,000 within 4 weeks.
My lord, he is running an AC repairing shop. He can't afford it.
He has to pay. Then why he obtained rupees 11 lakhs?
My lord, out of this whole case, I have not counted a single penny. It was the case. It is the case
I
that
am not going to consider that defense. It was believed to be towards a legally enforceable date. What was that enforceable date?
Pardon, sir.
You obtained hand loan of rupees 11 lakhs in 2018. And you had to issue even check also, 2 checks.
Those checks are not even written by me. The checks are way
It is
of
not-
security.
It is not that also, that defense is also not available now, Mr. Even if it is in your handwriting or his handwriting or third party's handwriting, it is of no use. If it bears your signature and you don't dispute that signature, matter ends there.
My lords, as per documents on hand right now, there is a dispute of 1 lakh rupees. I may please be. I request before the court to just clarify that, because I have not received the certified copies from the lower court. That may have been missed out
What certified copy?
due to clerical
What certified copy?
of the payment slips, my lord.
Which payment slip?
Payment money deposited or handed over by the complainant. Sorry, accused applicant.
What amount he has paid?
Total 50%, 5,50,000 he has paid.
But it is of no use. It is never paid before the court even to the advocate of the complainant. So you can't count that. Make up your mind fast. You have to deposit the amount first.
Yeah, please, sir.
Within 4 weeks. You are Mr.
Y.V. Gupta.
You yourself Yash Gupta. Third Mr. Yash Gupta, learned advocate for the petitioner as accused. According to his submission, 50% of the check amount is already deposited, paid to the complainant through his advocate. However, he is able to show only payment made before the court to an extent of 4,50,000 towards the check amount. At any rate, he submitted that the petitioner as accused is present before the court.
Yes.
Call him. 4 અઠવાડિયાની અંદર બાકીના 6.5 લાખ રૂપિયા ભરવાના છે, નહીં તો કસ્ટડીમાં જવાનો વારો આવશે એ દિવસે. એટલે અત્યાર સુધી 2018 નો ચેક છે. 5 વર્ષ તો એમને એમ તમે કાઢ્યા, 4 વર્ષ. ભૂલ એક જ વાર થાય ને ભોગવવી જ પડે. ચાલો એટલે ચાલો નહીં ભરો તો જેલમાં જવાનો વારો આવશે. એટલું જ તમને કહેવા માટે ખાલી તમારી હાજરીમાં લખાય છે એટલા માટે. એ અત્યારે હા અત્યારે ડિસ્પ્યુટેડ છે. એ આવશે ત્યારે એ સમજીશું સાંભળીશું. 4 વીક નો આપ્યો ટાઈમ, 1 મહિનાનો. Who is present before the court and identified by him is ready and willing to deposit remaining amount of check within a period of 4 weeks. Six weeks लगा चलो 6 अठवाडिया आपू 1.5 महीना. 6 weeks from today. Registry is hereby directed deposit before this court. No? Registry of this court. Registry is hereby directed to accept the same as and when deposited on or before the returnable date. Hence, notice returnable on 6 વીક ની જ આપું તારીખ ગણીને, એટલે કોઈ ડિસ્પ્યુટ જ ના હોય. આમાં જોઈ લો 6 વીક કેલેન્ડરમાં. 20 December. Till then, if any warrant is issued, warrant of arrest is issued pursuant to the conviction and confirmation thereof by the appellate court, comma, it shall not be executed ત્યાં સુધી વોરંટ ઇસ્યુ થયું હશે તો એક્ઝિક્યુટ નહીં કરે, પણ 6 અઠવાડિયામાં પૈસા અહીંયા જમા કરાવવાના. બરોબર, એમને સાંભળીને બાકીના પૈસા જો એ એક્સેપ્ટ કરતા હોય તમે ભરેલા એના વકીલને આપેલા, તો કોર્ટને તો કોઈ વાંધો ના હોઈ શકે. પણ એની ગેરહાજરીમાં તો માની ના લેવાય ને. રાઈટ, 6 અઠવાડિયાની અંદર પૈસા ભરવાના.
Matter regarding the land grabbing in this society. Very small portion of the land in this society which was grabbed by the respondent. Main confession of the complainant, original complainant, and here in the revision application, that this society is originally constituted in 1970. At the relevant point of time, they approved the plan of the society.
You take me to the impugned order first.
This shall be page 41.
Court will first kept it for inquiry verification first on 11/7.
Yes.
All right. When this order came to be passed, 310. All right. All right. Read this order. It is only 2-page order.
2-page order. Yes. ફરિયાદી દમચંદ્રભાઈ સેકન્ડ પેરા ફરિયાદી હકીકત ફરિયાદીએ કોર્ટ રૂબરૂ જણાવેલ હકીકતો તેમાં રજૂ કરવામાં આવેલ દસ્તાવેજી પુરાવો ધ્યાને લેતા આરોપી સ્વામી વિવેકાનંદ પબ્લિક સોસાયટીના પ્લોટ નંબર 7 પબ્લિક 2 નો પુરવઠો ધરાવે છે અને આ મિલકત આરોપીએ 30/9/2014 ના રોજ દસ્તાવેજ કરી વેચાણ રાખેલી તેની બાજુમાં સોસાયટીના કોમન પ્લોટ નંબર 16 અને 17 આવેલા છે. 1516 સોરી જે કોમન પ્લોટ 52 કોમન પ્લોટ પર આરોપીએ આશરે 8/50 250 ફૂટનો ગેરકાયદેસર કબજો સને 2021-22 માં કરેલો હોવાનો આક્ષેપ છે. જે ગેરકાયદેસર કબજો ખાલી કરવા જણાવેલ હોવા છતાં આરોપીએ કબજો ખાલી કરતા નથી. ફરિયાદી દ્વારા પ્રથમ કલેક્ટર કચેરીમાં લેન્ડ ગ્રેબિંગ સમિતિ સમક્ષ 24/21 ના રોજ અરજી કરેલી, જે અંગે લેન્ડ ગ્રેબિંગ સમિતિને બેઠકમાં મુદ્દા નંબર 6 અનુસાર ચર્ચા અનુસાર સિટી સર્વે સુપ્રિન્ટેન્ડન્ટ ભરૂચનો 6/4/2022 નો રિપોર્ટ તથા માપણી સીટ મુજબ સવાલવાળી જગ્યામાં કોઈ દબાણ જણાતું ન હોય ફરિયાદીની અરજી નામંજૂર કરવામાં આવી. આ કામે સિટી સર્વે સુપ્રિન્ટેન્ડન્સી ભરૂચનો 6/4/2022 નો રિપોર્ટ અને માપણી સીટની નકલ રજૂ કરવામાં આવેલી છે, જે ધ્યાને લેવામાં આવેલ છે. તે મુજબ આરોપી દ્વારા કોઈ દબાણ કરવામાં આવેલું હોવાનું જણાતું નથી. આ કામે ફરિયાદી તથા આરોપી વચ્ચે થયેલ પત્ર વ્યવહાર ઇન્ટુ બ્રેકેટ નોટિસોની નકલ પણ રજૂ થયેલી છે, જે પણ ધ્યાને લીધી. આરોપીની મિલકત અત્યાર સુધીમાં 4 વખત ટ્રાન્સફર થયેલ છે, જેમાં પ્રથમ વખત 1992 તથા બીજી વખત સને 2008 ચોથી વખત 2014 વેચાણ થયેલ છે અને ટ્રાન્સફર થયેલ છે. આ તમામ દસ્તાવેજોમાં પ્લોટનું ક્ષેત્રફળ 210.84 ચોરસ મીટર દર્શાવેલ છે. સદરુ કાગળોમાં તારીખ 21/3/2022 ના રોજ કરવામાં આવેલા પંચકેસની નકલ પણ રજૂ કરવામાં આવેલી છે, જે પંચકેસ પંચોની હાજરીમાં સોસાયટી સિટી સર્વે દ્વારા કરવામાં આવેલ છે, જે વંચાણ લેતા સર્વે નંબર 20/1 માં ની મિલકતમાં ફરિયાદી તથા વાદીની રૂબરૂ સિટી સર્વે કચેરી ભરૂચના સર્વેયરની પંચો રૂબરૂ માપણી કરેલ છે અને સ્થળ સ્થિતિ મુજબ કબજા મુજબ માપી કરેલ છે, તે બરાબર છે. સિટી સર્વેના સર્વે દ્વારા 21/3/2022 ના રોજ ફરિયાદી દત્તચંદ્ર શાંતિલાલ ચુનાવાલાનો જવાબ પણ નોંધવામાં આવેલો છે, જેમાં ફરિયાદીએ જણાવેલ છે કે હિયર ઇઝ મોસ્ટ ઇમ્પોર્ટન્ટ પોર્શન. સદર મિલકતની 2/1/98 ના હિસ્સા માપણી સીટ આધારે તથા કબજા આધારે માપણી કરવામાં આવેલ છે, જેના કબજેદાર નૈષદ કૃષ્ણકાંત મજમુદાર વગેરે ધારણ કરતા હોય તેના વિરુદ્ધ અમોએ લેન્ડ ગ્રેબિંગ હેઠળ ફરિયાદ કરતા ઉપરોક્ત મુજબ માપણી કરતા હદ અને ક્ષેત્રફળ સિટી સર્વે મુજબ મળી રહે છે, જે અમે જાણીએ છીએ. હવેમાં વધુ કોઈ વિવાદ થાય તો તેની ચકાસણી કરી ઘટતી કાર્યવાહી કરવા આપ શ્રીએ જાણ સારું. આમ ફરિયાદીનો પોતાનો જવાબ વંચાણે લેતા આરોપીના પ્લોટનું ક્ષેત્રફળ સિટી સર્વે મુજબ બરાબર છે. ઉપરોક્ત સંજોગો ધ્યાને લેતા લેન્ડ ગ્રેબિંગ સમિતિ દ્વારા પણ તપાસ કરી ફરિયાદીની અરજી નામંજૂર કરવામાં આવેલી છે અને ફરિયાદીના પોતાના સિટી સર્વે રૂબરૂના જવાબ મુજબ આરોપી દ્વારા કોમન પ્લોટમાં કોઈ ગેરકાયદેસર કબજો કરવામાં આવેલો હોવાનું જણાતું નથી. ત્યારે આ કામે આરોપી સામે પ્રોસેસ કાઢવા જેટલો પુરાવો રજૂ થતો ન હાલની ફરિયાદ રદ કરી ફાઇલે હુકમ કરવામાં આવે છે. My main contention regarding now the into bracket. The concerned learned judge pass an order upon this statement, which is deposition before the concerned authority. સદરુ મિલકતની તારીખ 2/1/98 ના હિસ્સા પ્રમાણેની. My main contention regarding the society was established in 1970 at the level point of time. These all the plots are distributed to the members of the society. So none of the authority look into that original map and the contentions. This is the main contentions which is
For
left.
what offenses you have filed the complaint? Encroachment is an offense.
Encroachment.
Encroachment is an offense or a civil right?
Under the
If at
provision
all
of the
there
land grabbing, under the provision of the land grabbing.
Land grabbing, there is no land grabbing at all because committee has also not found any land grabbing, Mr.
Here in this society, when
If you want to establish your right under the measurement sheet, old measurement sheet, you have to establish that right before the civil court. Otherwise, court has found as per the documents and measurements
But the
available with the city survey superintendent.
Please, sir,
It
please,
is,
sir.
there is no encroachment at all of any inch. There is no question of grabbing at all. Yes.
My main contention regarding the, none of the authorities look into the original map and the society.
Original, if you have to establish that original map and write in the civil court.
But
When
when a
according to
person-
your own
when a
statement
person-
recorded on 21/3/2022,
Please,
but he is in possession of that very area which he was granted.
main contention upon that also, upon that also.
File the civil suit to prove your
Upon that
right.
also, when the society is go for the authority for the payment which was be installed in the society, after the completion of the paper work,
Court is not
This-
concerned with that accounting and that payment made, Mr. There is no grabbing by law land grabbing act. When he is found to be in possession of what area allotted to him or granted to him or purchased by him, there is no
that is
question of grabbing.
2010. 210.
Mr. You have your statement is dated 1/3/2022. At that time also no encroachment.
He
was
is
found.
saying about the that
It is-
measurement which has shown
No.
by the surveyor.
સદર મિલકતની તારીખ 2/1/98 ની હિસ્સા માપણી સીટ તથા પછી વાંચો આગળ કબજા આધારે માપણી કરવામાં આવેલ છે. માપણી સીટ થી કબજો જુદો હોત તો એ એન્ક્રોચમેન્ટ હજી કદાચ કહી શકત તમે. કબજો એટલી જ જગ્યાનો છે. Read it again. And first transaction of sale is in 1998. He purchased, who purchased in 98?
Please read it.
And all that civil right has to be established before the civil court. Not in the criminal court, that too in the complaint filed under Land Grabbing Act. સોસાયટી નો કોમન પ્લોટ હોય એને પ્લોટ નંબર જ ના હોય કોઈ દિવસ મતલબ 2 નંબર 15 ને કોમન પ્લોટ તરીકે જ ઓળખાય પ્લોટ નંબર તરીકે ઓળખાય જ પ્લોટ નંબર હોય તો એ જેના પ્લોટ નું એન્ક્રોચમેન્ટ હોય એ ફરિયાદ કરે.
Originally map is there in your office.
I am not concerned with the map.
Which I have not produced before the
I am
other
not
court.
concerned
But
with the
just
map,
for the
Mr.
clarification regarding the plot and common plot,
I am
here
not-
is the map.
I am not
This is
concerned
common
with the
plot,
map
shown as a
right
common
now.
plot.
I am not concerned with the map right now. Your complaint is also scrutinized by the land grabbing committee, specially formed, headed by even collector, revenue authority. There is nothing in the complaint. If you
Under
have
section
any
3, 4 and 5 of the Land Grabbing Act, this complaint
3,
was filed.
4A and 9 only. The laws land grabbing act. That's all. Or you want to add anything, Eric?
This present applicant produced 40 documents before the collector. Some of them I produced before this honorable court. But one of the document which just I see that on 6/5/2022, they applied for a certified copy of the original record of the society before the Deputy Collector and the Prant Adhikari Bharuch. And he replied on 6/5/22 that this is very old record of 47 years, so we cannot find this on record. Regarding the exact measurement of the plot area which was given to this present applicant by the fourth transaction.
Anything else you want to add, Mr.?
Honorable Court, permit me to add something. This documents produced before the.
I'm not concerned with any document to be produced. The documents which were already produced by you along with your complaint, court has considered and court has found that there is no land grabbing at all.
But in the order, my lord, in the order, there is not a single word regarding the 1970 when the society is established.
1970, court is not concerned whether there is any encroachment or a grabbing of a land and that too of a society or not. That the court has to consider. Even land grabbing committee has also not found any encroachment or any grabbing. So this petition is filed. This revision.
Then may I have liberty to go before this withdrawal with the permission to go for the before the civil court. If this were
for that, you need not any permission. Need not have any permission. You can always go. Mr. Smoke C. Patel, learned advocate for the applicant, seeks permission to withdraw this application with a view to avail remedies available under the civil law.
please.
As such, no such permission is required, but this permission as prayed for is granted. This petition stands, this application stands disposed of as withdrawn.
People have respect. In the 14 liters in the 15. Who have
Please note. Present petitioner arrested in connection with the offence registered at ACB Police Station, Gujarat, first year number 5 of 2015. So offence punishable under section 2. I'm a private person. Accused number 1, Mr. Patadia, already filed a application miscellaneous application number 1 of 2021. Case number 121. Honorable this High Court granted interim relief to the previous accused number 1. One of 2021. Okay. I submitted your order before this court by 1. What's your page number 121? Yes. No, Lordship. It is continuous. It is here on here. Lordship, it is pending before this honorable court. Interim relief already granted by this court. You see petition. No. Yes. Please, Lordship. But that's really. Yes. Lordship on order. Thank you. Para two. Page number 93. All both the parties considering the entire record on behalf of the advocate appearance for the accused number 2. It is mainly submitted that there is no prima facie evidence against the state accused for framing of charge. Said that he is not involved in the offense. Merely their name in incorporated in the statements of the witnesses. It is submitted that considering the statements from the record, it is not a case of conviction in any section of the same act. For accused number 2, all contents of the complaint, section 227 of CR15, and section 7, 8, 12, 13, 1A, 2, and 15 of the Prevention of Corruption Act in the application. Complainant has been referred by learned advocate and is submitted that no demand has been made by the present applicant, no work of land is done by the applicant. It is decided with the accused number 3. 8 to 5,04,000, out of which 4,45,000 was paid. It is submitted that the affidavit is filed by the investigating officer, which is contrary to the audio conversation. It is submitted that the applicant is not a government servant. The only allegation against the present petitioner is that the agency and the allocate the work for accused number 3, who is the agent of the present accused. No evidence is there to frame the charge against the applicant. No evidence against the present applicant that he has taken talk with any government servant. It is submitted that there is no sanction against the accused number 1. It is submitted that their time left and failed the investigation officer had not investigated about the agency. The present applicant had not talked with the accused number 1. The mobile number stated is not a present applicant. Considering the argument, the learned advocate has paid to discharge the accused. On behalf of the state learned advocate, public prosecutor Mr. Tripathi has referred the complaint and submitted that all the accused are together committed the state offense. The intention of all the accused was common. Charge sheet is also filed under section 34 of the Indian Penal Code. It is submitted that the specific allegations are made against the present accused. The script of conversation of the present applicant with the co-accused is on record, which specifically indicates the role of the present accused. Number 2, it is in this offense. It is submitted that no sanction required against the present applicant, as he is not a government servant. And so far as sanction against the other accused is concerned, it can be obtained later on. It is submitted that the committee is committed by all the accused together. In furtherance of the common intention, hence it is not necessary that the accused should have made demand directly. Investigation, where it was or not, will be decided at the time of trial. At this stage, as per the section 227 on the grounds, proceedings against the accused are required to be considered offense under section 15 of the Act is for the private person. It is further submitted that for the very beginning, in the FIR, name of the applicant has also been disclosed. During the investigation, also involvement of the present accused is found. Prima facie case is there against the same accused. Hence, the application is required to be rejected. The Honorable has considered the arguments advanced by both the parties. Section 227 of the Code of Criminal Procedure. Section 227. It is upon consideration of the record of the case and the document submitted therewith, and after hearing the submission of the accused and the prosecution in his behalf, the judge considers that there is not sufficient ground for proceeding against the accused. He shall discharge the accused and record his reason for so doing. The court, while considering the question of framing of charge under Section 227, he has power to fix and weight the evidence for its limit, purpose of finding out whether or not the prima facie case against the accused has been made out, where the material laid before the court disclosed carrying suspicion against the accused, which has not been properly explained. The court will be fully justified in framing the charge and proceeding with the trial. In the case on pursuing the person along with the discharge with the charge sheet, the name and the role of the present applicant has been specified in the FIR. The mobile number which was kept under interception and the conversation on it from 23rd September 2015 to 22nd 10 2015 was recorded, and the script of the sample produced by the investigating officer. Detailed conversation of the present accused with other co-accused is there in the script. The accused person has talked to on conference. Section 34 of the Indian Penal Code is stated below, which is considered by this court. Section 34, act done by several persons in furtherance of the common intention. When a criminal act is done by the several persons in furtherance of common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. In judgments 2015 Gujarat Supreme Court, in the case of between the Ambati Janardhan Rao versus Central Bureau of Investigation of the Honorable High Court of Gujarat in Para 54 has held that if therefore appeared that in the trial court did not record reason why the accused person should not be discharged, the trial court looked into the material on record and found that the manner in which the lease deed was executed and the transfer of the case all rights were permitted creates strong suspicion against the accused. In fact, the court is required to assign reason in case of discharge of the accused, but in case of framing of charge, the assigned reason is not required. The court is only required to form an opinion that there is ground for presuming that the accused has committed the offense. The reason for not assigning reason for the framing charge at this stage is only with the view that if any person is assigned that may affect, prejudice the case of the accused at the stage of the trial. As per the above judgment, the court is required to assign reason only in case of discharge of the accused. As discussed above, considering the entire record of the case and the documents submitted and after hearing the submission of the accused and the prosecution, this court considered that there is sufficient ground for proceeding against the accused as per Section 27 of the CRPC and above referred judgment. If the accused is discharged, then the reason are to be recorded. In this case, though reasons were not required to be given, this court has discussed the reason for allowing the application of the accused number 2. The judgment rely upon by the applicant in 1978 lawsuit, so that 4 judgments in this case considered, but as discussed above, there are sufficient grounds for proceedings against the present accused to proceed is not a case of some suspicion. Hence, the authorities are not helpful to the objective. Upon consideration of the record of the case and the document submitted, there is sufficient ground for proceedings against the present accused and for arriving at conclusion of the act. of the commission and conduct of the accused. There is a requirement to take trial, and in the light of the aforesaid reason, this court is of the considered opinion that the application referred by the accused number 2 deserve to be rejected. Anand Dalwadi, accused number 3, private person. It is alleged in the complaint that they are the agent of accused number 2. Yes. Yes. It is only, but no lordship. But lordship, mere allegation is not sufficient to mere lordship. But whatever the what lordship, yes, lordship, I submitted the lordship entire script of the telephonic conversation between the party, between all the accused are submitted with the charge sheet by the IO, in which kindly look at the page number. No, not at all. Only one talk. Only Bharatbhai શું કહેવા માંગે છે બસ. Bharatbhai, I am Bharatbhai, but not doesn't talk anything about the lordship. It is only allegation. They are not my servant, not my any way connected. Anand bhai. No, lordship, they are not connected with me. I am lordship. No lordship. It is not on record. One 103. आरोपी आनंद रजनीकांत दलवाड़ी मोबाइल नंबर 100 पितियास किरण सिंह चावला मोबाइल नंबर 100 अब्दुल लतीफ पितियास पी ऑफ डेप्यूटी कलेक्टर. हाँ, connected with the accused number 1, main accused number 1. Number 1 and 2. It is alleged in the complaint that number 3 is the agent of my firm. It is only allegation. But lordship, kindly come to the page number. हाँ, और ત્રણના જે કન્વર્ઝેશન છે એમાં મારું તો કોઈ જગ્યાએ આવતું જ નથી. મારું કન્વર્ઝેશન જ નથી. કરવામાં આવેલ છે જેની સ્ક્રિપ્ટ તપાસ કામે રાખવામાં આવેલ છે. જેવો ભરભાઈ પોપટ સુથારનો મોબાઈલ નંબર 100 છે. મારો મોબાઈલ નંબર આનંદ રજનીકાંત દલવાડી નાયક ફરિયાદી સાથે આનંદ દલવાડી ઉપર આનંદ રજનીકાંત દલવાડી નાઓએ સાથે મોબાઈલ ઉપર વાત કરેલ છે. But nothing in the script. Nothing in the script. हाँ, बताओ आपने सर. For example, page number 106. For example, એની અંદર બતાવ્યું છે લાસ્ટ 3 લાઈન ભરત સુથાર સાથેની વાતચીત. આનંદ ભરત ઓમ પ્રકાશ શું થયું? આનંદ અને ભરત ઓમ પ્રકાશ કાલે આરટીજીએસ થશે વોર્ડ બપોરે 1:30 વાગે એટલે કે પછી પૈસા મોકલવાનો છે. But lordship 3 tap already failed. 3 tap. but it is not a case of acceptance or consideration or proposal, but entire charge sheet. Lordship, entire charge sheet, paper of charge sheet already more than 2,000 page, but not a single line evidence. But Lordship, at the stage of framing of charge, Lordship, at least script be heard by this court. Script be heard by this court. Audio and video script is there, also submitted by the investigating officer. At least Lordship, call the papers and IO. HR Hasmukar Gurjar.
applicant applicant is accused, and therefore I see no reason to entertain this revision application filed by the applicant as accused, challenging his rejection of challenging order rejecting his discharge application. Hence, this application is rejected. Time of orders. Mediation failed.
Unfortunately, mediation failed, Lordship.
What is the main revision application for?
Lordship, that accused had issued the check, Lordship. And as per the
This under 138.
138, and as per the order passed by this court, Lordship, I have deposited entire amount, Lordship. It was one of the condition to grant the bail, Lordship. So I have deposited entire amount, Lordship. And thereafter, we try to settle because both are from the same village, same community. They are doing the same business.
No,
therefore, we have tried to settle.
What was the check amount?
897, Lordship.
That is already deposited before this court or
before the trial court, Lordship.
Before trial court, entire amount is deposited.
Entire amount, Lordship. In fact, Lordship,
where is the receipt? It is only 20%. I am having the receipt of 20%.
No, thereafter, as per the order passed by this court, Lordship, I have deposited.
I am asking you that receipt. And it was to be deposited before trial court or before this court?
No, before trial court, Lordship.
Where is that? Order dated? You were directed by, you had shown willingness to deposit the same within 4 weeks from that date, that is 17/12/2021. Show me that within 4 weeks you have deposited the rest of the amount.
I think the accused has sent you a receipt, Lordship, but it is lying in my office, Lordship. May I request? I will produce on next day, Lordship.
On failure of mediation proceedings, this matter is placed for orders. However, since the matter is at admission stage, registry is directed to notify the same for the purpose of admission hearing on.
Lordship.
Come with the receipt of deposit of entire remaining amount
Lordship.
or remain present here or else the non-bailable warrant will be issued against you.
Lordship.
Cancelling the bail.
Lordship.
And you also instruct your client what he intends.
What had happened is my learned friend was also present when the mediation was going on. Though he has deposited 8,97,000, initially he agreed only to pay us 4 lakh rupees.
Mr. You just
Yes. We
take
are
the
ready
instruction
for
what he,
8,97,000.
then matter can be disposed of.
Lordship, I have filed one civil application for additional evidence, Lordship. In fact,
Additional
there was no
evidence.
outstanding amount, Lordship, because we have already paid, Lordship. We have taken the
Show me
receipt.
the provision where the application for additional evidence in a revision application is maintained.
Since my
Show me any provision.
I understand, Lordship.
You have missed that bus. If at all you had that good case.
Document
The only reason for failure of mediation was that they are not ready to give us entire 897.
You are you ready to accept that amount or not?
My client,
Make up your mind fast.
I will just.
On that day, I will dispose of the whole matter if you are ready for that.
Yes.
Lord.
Black.
This is also listed for orders. Here also mediation has failed. It is-
Maintenance proceeding?
Please, Your Lordship.
Since the mediation proceedings have failed, registry is directed to notify this matter for admission. It is still to be
Notice-
admitted,
the notice has already been issued.
but it is yet not admitted
No,
for admission hearing on.
Lordship. Obligation.
Civil application for delay condemnation. There is a 43 days delay.
Delay
Filing
in
revision application.
revision application is against which order?
My lords, seeking discharge from the offense under section
Oh.
307.
Trial has yet not concluded.
I'm not aware about that, my lords. The order is at page.
Order is dated 17 February 2019.
Yes, my lord.
Still trial has not concluded.
I'm not aware about that.
Notice
I may
is
take
not
instruction.
issued even in this case. This application is filed praying for condonation of delay of 43 days in preferring the revision application. Notice returnable. However, pendency of this application and oblique or revision application before this court may not be treated as stay against proceedings before the trial court. 2019 ડીલે કોન્ડોનેશન ફાઇલ કરીને કોઈ દાડો નોટિસ ઇસ્યુ ના થઈ 3 વર્ષ સુધી ટ્રાયલ ના ચાલ્યો ડિસ્ચાર્જ રદ થઈ ગઈ તોય you also get that instruction and why trial has not commenced.
My lords,
Get
even
that
the
instruction.
both parties has filed a consent proceeding before this honorable court. That
Get it consent by causing right now, but you can't wait on this ground.
Please, ma'am.
Get whole case cost even with consent if you are court is doing it. I will not keep this matter pending here. So next.
On behalf of Mr. Gandhar, sir.
we request for some time.
Why?
As we are trying to contact with our client, but this
Your good
section
name,
has-
please.
Yes, sir.
Your name, please.
Madhvi Papurva. Madhvi Papurva.
Mr. So-and-so for Mr. D.H. Kandhare, learned advocate for the applicant 6 times. However, pendency of this application or the revision application in which this miscellaneous from the docket sheet, it appears that on majority of the occasions, the matter is adjourned either sick note being filed by the learned advocate for the petitioner applicant, sick note or leave note. Not only that, on 2 of the occasions, that is on 2/12/2019 and 6/1/2020, as recorded by the court, despite matter called out twice, learned advocate for the applicant did not remain present. They also, when the matter is called out, learned advocate for the applicant is not present. However, in the interest of justice, with a view to give one more chance, SO2. Pendency of this application or the main revision application may not be treated as a stay granted against the order impugned.
So this is revision against 125 order of the Assembly Judge Ahmedabad. This lady married to me on January 20. After that, she got divorced. She was to produce me official divorce deed, but she did not. Then paper divorce before the notary she produced. And thereafter she lodges maintenance petition against her existing husband. When we represented it before the family judge, she withdrew that application, and my petition is decided by the family judge. I have lodged family suit for divorce under section 5(1). That she is legally, she's as on today, wife of someone else, and she has married with me, so this should be void, declared void. But family judge did not consider everything, and even responded. No, not decided, not considered my submission. Yes, sir.
By you.
Yes, sir.
Still pending.
Yes, sir.
However,
She is not divorced. She was to give me the divorce paper from the court, divorce order. And instead of that, after marriage she got divorced. After marriage with me, she got divorced on notarized paper.